So let me know when you're ready, Mike.
Ready.
Ready? Let's close the door. I'm sorry guys, it might be a little warm, but if we don't have the door closed, it won't work. So hi, I'm Linda Gerchick, designated broker, Gerchick Real Estate. I hope you all know who I am at this point. But today we have a very exciting topic, and it's called the legal part of the fix and flips. And we have Chad Kaffer, Davidson and Kaffer. Chad is our Chad is our entity attorney, our real estate attorney, and we have a great relationship for a long period of time. Chad, take it away.
Okay. As Linda said, my name is Chad Kaffer. I know some of you know me. I have been an attorney for about 13 years. Our law firm, Davidson and Kaffer, has been in the Valley for about 26 years. We're a little different from some other law firms. A lot of firms that handle transactional work and any formations that also do litigation. Typically, those areas are separated by attorneys. There are attorneys who handle transactional matters. There are attorneys who handle litigation. Our practice is pretty much divided 50-50 with the attorneys each practicing transactional law and practicing litigation. And the reason for that is we believe that if you don't see how a deal falls apart in court, you don't know how to put it together to protect your clients. And the vice versa is also true. If you don't see how the deal is put together, you don't understand it when you're defending your clients in court. So that's sort of the reasoning for that. Today what we're talking about is fix and flips. And essentially the idea is a lot of people think that they understand fix and flips. It's probably one of the most popular ways to invest in real estate. I buy a piece of property, I put a little sweat equity into it, I flip it out for a profit. What a lot of people don't understand is the actual legal ramifications of doing that. I know, for instance, that there are a lot of TV shows where you see people who are doing, you know, My First Flip. The first thought in my head when I see those shows is what you're doing is horribly illegal. If you think about it, would you want to buy a property from someone who just, for instance, changed the electrical service on the property, who has never done that before in their lives? Would you want to buy a property from someone who rented a backhoe, dug out a portion of the lawn in order to make a pool, and did the cement and the gunite themselves? Probably not. And that's, in a lot of instances, what's happening there. Fortunately, the law doesn't allow people specifically to do that. There are certain things that you can do that comply with contractor licensing statutes, certain things that are exemptions to contractor licensing statutes. But the thrust of this presentation is that what you're essentially trying to do is to do things within the law. There are disclosure obligations required with fix and flips. There are things to look for when you're purchasing fix and flips with respect to those disclosures. And there are things that you need to know in terms of the professionals that you need to hire in order to properly do a fix and flip. So we'll go through some of that a little bit. First of all, we're going to discuss who has to be licensed. Secondly, what to look for during inspections. When you purchase a property, you typically inspect that property. What should be on a seller's disclosure statement? What should you look for around the property? The as-is addendum, what it is and what it isn't. This is probably something that gets confused by realtors and by purchasers and sellers more than anyone else. A lot of people think that the as-is addendum is a get-out-of-jail-free card. If I put out an as-is addendum, I don't have to disclose anything to you. I don't have to do anything with respect to the property, and it's just not true. Using a benz to protect your buyer, which is a buyer's inspection notice and seller's response. How do you protect your buyer whenever the buyer's buying? What's supposed to be in that benzer? And finally, getting the seller to use licensed contractors. And we're talking about using licensed contractors when you're asking for repairs on a property. One of the largest misconceptions within the real estate community is that I don't have to use licensed contractors to get repair work done. And in general, that's not true, except in very specific circumstances. Do we have the clicker? Okay. So the next slide, why does it matter? Why does it matter whether or not we properly comply with licensing statutes for contractors? Well, it matters for a bunch of reasons. The first reason is that there's no warranty of work for the buyer. Meaning when your buyer buys a home, if they have the understanding that what they're getting is a home that has warranted work, so if anything fails, they can go back to the registrar of contractors, bring that contractor in and ask for that to be fixed. They're not actually getting that with an unlicensed contractor, which means in essence they have a home that if there's anything wrong with the work, there's nothing they can do about it. Secondly, a claim for rescission against the seller. As a seller of a fix and flip property, the one thing that you do not want to have to do is to buy the house back because you failed to get a properly licensed contractor in the first place. That's the worst case scenario that can happen to you. A claim for damages. And this comes up all the time. For instance, I had a case where my client had purchased a piece of property. It was a fix and flip. The seller had the property, saw that there was massive water damage, and essentially just hired a crew, had them put drywall up over the water damage, sold the property, she purchased it, and the first time that it rained, water was leaking through like a sieve. They popped off the drywall, and it turns out that all of the wood had finally just dry rotted out from being wet and getting dry and being wet and getting dry, so that the whole one side of the house was about ready to fall down. In order to fix that, it cost $80,000. The seller of that property wrote a check for the $80,000 in order to resolve it. That means that any profits that he was going to realize have been eaten up in paying out claims because he didn't get a licensed contractor. The fourth, criminal charges. This is the thing that a lot of people don't know, but failing to use a licensed contractor when you need to have a licensed contractor is technically criminal under Arizona state law. It can lead to a Class 1 misdemeanor, which allows you to be put in jail for up to 6 months and fined $2,500 per offense. Now this is typically not going to happen for a first-time fix and flip, but if you have somebody who repeatedly violates the contractor licensing statutes, it is something that does happen to those people. In fact, if you get on the ROC's website, if you've ever done that in the Register of Contractors, they'll have a whole list of people who were subject to these sorts of fines. And finally, a prosecution for consumer fraud. Now there are two ways to bring a consumer fraud claim. The first type of consumer fraud claim is a civil consumer fraud claim. The second is a criminal consumer fraud claim. The criminal one's brought from the Attorney General's office. The civil one is a claim that you can make essentially with respect to a purchase of real property that just says, look, what you did was a deceptive practice. You gave me the impression that a licensed contractor was used to do these improvements. The licensed contractor was not used. As a result, I should be able to bring a claim against you for damages or for rescission of the purchase contract. So let's talk about contracting. What does it mean to contract? Who is a licensed contractor or someone who's required to be licensed? Well, these are the statutory definitions. It's anyone who personally or through others, directly or indirectly, 1, supervises others to construct, alter, repair, add to, subtract from, improve, move, wreck or demolish any building or other structure, project, development, or improvement, or to do any part thereof, including the erection of scaffolding or any other structure work in connection with the construction. It's very, very broad. It's very rare that you're going to do anything with respect to a piece of property in terms of construction work that's not going to fall under that definition. It's also anyone who connects the structure to utility services, anyone who provides mechanical or structural services, or anyone who submits or purports to submit a bid for any of those activities. And this is the big one with respect to fix and flips. Typically, what a lot of people think that they have the ability to do, you'll hear people, for instance, designers. We on occasion will represent interior designers. Interior designers are, on occasion, of the belief that they have the ability to go out and hire subcontractors and to submit bids and to get bids and to get a little bit of money on the top of submitting or getting bids. They don't because they're not licensed. The homeowner has to do this. So I think that you can agree with me, it's a pretty broad definition. It's a very rare circumstance where you're not meeting one of these definitions when you're dealing with construction.
Nothing.
So the exceptions, and these exceptions are applicable only to single-family residence owners. First, there's the owner-builder exception. Second is the owner-developer, which is the flipper, and the third is a handyman. We'll talk about those in greater detail, but essentially an owner-builder is someone who owns their own home, is going to live in their own home, and does some work around the home. The owner-developer is someone who purchases the property with the expectation of fixing up the property and selling it. And then a handyman, this is probably the worst and most misused term within contracting. The fact that you go out and do some work does not make you a handyman. A handyman is a very specific technical definition under the statute. It's somebody who does less than $1,000 worth of work in the aggregate, actually advertises in a way that they're a handyman, meaning that they say not a licensed contractor, and that they're not doing certain specialty contracting work. Move to the next slide. So an owner-builder. Who's an owner-builder? And we talked about this. This is the homeowner. This is someone who is an owner of property who builds or improves structures or appliances on the property and do the work themselves with their own employees or with duly licensed contractors. So the basic idea is if I live in the house, I can do the work myself. There are exceptions to that, and they're sort of the big exceptions. The rule is if somebody could potentially die because of the work that you did, you don't have the right to do it. So it's electrical, it's plumbing, it's a pool, it's roofing, and it's the mechanical system or HVAC. Those sorts of things a homeowner cannot do for themselves. they're supposed to hire a licensed contractor. There's an assumption that's made because people play around with this definition. You say, well, I lived in the house as I was doing the work, so technically I'm an owner builder. I'm not an owner developer or a flipper. This is my house and I can do the work. If you sell that house within 1 year of completion of the work, or you fail to properly apply for permits, you are likely still going to be treated as someone who should have been a licensed contractor when you did the work. Now the second category, and this is what we were talking about when we're talking about a flipper, this is an owner developer. It's a person who purchases the property with the intent of developing the property and selling it. Now, these people have to use their own general contractor or use specialty contractors. Now here's how it's a little bit different from a lot of other construction scenarios. In essence, as the owner of the property, you can act as the general contractor, meaning that you're hiring directly the subs. When you do that, you have to hire licensed subcontractors for all of the work. So if you're going to have somebody do the painting, hire a licensed sub. If you're going to have somebody do the flooring, hire a licensed sub. Now, what some people do when they're doing owner developer work, when they're doing fix and flips, is they just hire a general contractor. Because a general contractor can do a lot of that work themselves. They can self-perform the work. If you're talking about doing framing, sometimes it's cheaper, believe it or not, to get a contractor who's going to do the framing themselves, do the flooring themselves, do the painting themselves, than to hire a whole bunch of subs who are each going to charge a markup on it. Can we get the next slide, please? Now let's talk about the handyman. Everybody's a handyman in Arizona. Just ask them. So with respect to the handyman exemption, this is probably the least understood portion of the handyman exemption. It has to be less than $1,000 in the aggregate for the project. Now, just about any fix and flip that you do, the aggregate work on the project is going to be more than $1,000. And that includes the cost of materials. So if I have to buy $900 worth of framing, and I have to pay my handyman $200, he needs to be licensed. And that is the aggregate. So if what you do in total is more than that $1,000, if you do work all over the house, you can't enter into a whole bunch of $1,000 contracts with the same person. That's an attempt to avoid the statute. You will be found liable if you do that. So that does not meet the handyman exemption. There has to be no permit required for the job. So if I had to get a permit to do something, a demolition permit, anything like that, I've got to hire a licensed contractor. And the person must specifically advertise that they are not a licensed contractor. Now let's talk about what we're looking for in SPUDs. Does everyone know what a SPUDs is? It's a seller's property disclosure statement. Seller's property disclosure statement is a statement that goes out at the time that you go to sell your property that gives a whole list of disclosures about a variety of things on the property. Has there ever been any work done? Do you know of any termite infestations? Do you know of anything essentially that would be material to the property? Or is there a highway nearby that creates noise? Anything like that. What we're looking for with respect to an owner builder, this is the person who's required just to disclose latent defects. And a latent defect is a defect that under ordinary inspection, I wouldn't be able to find out about. So if what happens is, for instance, and this happens all the time, somebody has subsidence and there are cracks. Patch the cracks, they paint the wall, they sell the property, and then the subsequent buyer finds out that there's additional subsidence issues and it continues to crack. This happens a lot up in the Rio Verde area because they've got pretty loose soil. If you fail to disclose that latent defect, as an owner builder, you're liable for that latent defect. If it's something that somebody wouldn't otherwise have discovered. For instance, the case that I talked about with my buyer, she purchased a home, they put new drywall up, they sent a home inspector through. There's no reason to know that behind the drywall there's wood that's completely dry rotted and split because it's covered up. That person has to disclose that latent defect. Now with an owner developer, the disclosure obligations are much larger. Not only do you have to disclose the latent defects, but you also, by state law, have to disclose the contractor's names and license numbers in all sales documents. I would be willing to bet that most of the agents that you deal with are unaware of this. And the reason that they're unaware of it is, this is part of the contractor licensing statutes, but it applies to sellers of real property and real estate agents. In all sales documents, and that includes in MLS listings, that includes in the seller's property disclosure statement, technically you should be giving those contractors names and their license numbers. Now the reason you're supposed to do that is because of that warranty obligation we talked about. If anything happens, I should know who I go back to and who I say, look, you did this work wrong, come back out and fix, you know, a nail pop in the drywall, come back out and fix the tile that's popped up that's no longer adhering to the floor. I should know who I go to do that. And that's how you do it, and that's how you know. This is where you meet your warranty obligations. Does that make sense? Okay. And this is the seller's property disclosure statement. The seller advisory, if you have ever engaged in this exercise of selling real property, particularly that you purchased, I advise you to read through the seller advisory on the SPDS. The advisory says if there's anything that you know that could potentially affect the consideration to be paid for the property, you need to disclose it. I get questions all the time. As Linda said, for about 5 years I was outside counsel to the Arizona Association of Realtors. One of the things they have you do is run what's called the AAR hotline. AAR hotline is a line that realtors can call, or their brokers can call, and ask questions. The most frequent question is, do I have to disclose X? And the answer to that is, if you had to call me, you have to disclose it. Every single time. And that actually goes to this extreme level that you would not anticipate. But to show you how far that obligation goes, there's actually a reported case law in some jurisdictions, particularly in New York, that it said that someone who placed their home on a haunted house home tour and had alleged that the home was haunted needed to disclose to a potential buyer that they believed the home to be haunted. And that buyer was able to rescind because they did not disclose that supposed haunting, that they believed that it was haunted. Now, I think that is insane. Wall-to-wall insane. But that's what the disclosure requirements require you to do. So if, for instance, and they do that here in Arizona, there are haunted home tours.
Is that a material fact?
Well, yes. I mean, in essence, that's what was argued. I'm sure I've got one of the attorneys from my office, I'm sure he remembers that one from law school, because everybody goes crazy and says, yeah, that's the craziest thing that you could possibly tell me. You're supposed to disclose that sort of stuff. You know, and there are certain things that you don't have to disclose. They're very specifically laid out, but for the most part, if you're asking the question, you need to disclose it. Latent defects with respect to construction, you need to disclose them. I had a client who wanted to know if he was liable. He'd done a fix and flip, and when they did it, they thought that the backyard looked terrible because it was entirely concreted. So what they did was, they put a little dirt down, they put some sod down, and they left it. Within a month it died, because the roots couldn't take purchase. And the people went out there to investigate. They dug down a little bit. They found out that it was all concrete for the entire yard. He wanted to know if he was liable. Yes, absolutely. If you didn't tell the buyer that this happened, you should probably write a check. That's what happens in every one of those instances. The next slide, please. The as-is addendum. We talked about this. The as-is addendum is not a get-out-of-jail-free card. The as-is addendum does not say you're absolving me from all liability or you're absolving me from the obligation to disclose. Again, if you're in doubt whatsoever, you have to disclose. So if you're familiar with the purchase contract in Arizona, the AAR standard form purchase contract, the as-is addendum specifically says that it's only waiving the warranty section of the purchase contract. So how is that different from any other purchase contract? Typically, if I enter into an agreement to purchase real estate under a standard form AAR purchase contract, there are certain things that I warranty will work. So the systems I say will work. Plumbing, HVAC, that sort of stuff. I'm telling you it will work, and if it doesn't work, you can make me fix that stuff. And then anything outside of that is part of the negotiation. If I give you an as-is addendum, I'm letting you know that I'm not warranting any of that. That's not part of our deal. You can still ask me to repair it, and if I don't, you can still cancel. But I don't undertake the obligation to repair those things. That's all the as-is addendum waives. You still are required, under every circumstance, to disclose latent defects with an as-is addendum. And I will give you an example. For those of us who've been dealing with real estate in Arizona for a few years now, in 2009, you may have heard about a real estate crash. Some people might have heard about that. The banks would list properties for sale with asset managers. The asset managers would say, give me a seller's property disclosure statement, and the banks would say, no, we're not going to list anything, we've never occupied the property. And in some instances, the agent would be aware, due to a prior walkthrough or prior inspection, that there was something materially defective with the property. the roof, the HVAC system, something like that, but wouldn't put it on the subsequent buyer's seller's property disclosure statement. That is always a violation of the S's addendum. You are still required to disclose latent defects as an agent and as a seller, as an individual seller. And that also includes a warranty due to unlicensed work. You can technically tell someone in Arizona, now bear in mind I'm not telling you to do this because it's a violation of contractor licensing statutes, but if you say, I used unlicensed contractors for everything in here, you will not have a warranty on anything. Technically, at that point, that buyer cannot come back after you for a lack of a warranty, cannot come back after you for a latent defect, cannot come back after you for a failure to disclose. They can't rescind the purchase contract under any of those circumstances because they've walked into the deal fully informed. Now, the registrar of contractors will take a different view of you than your buyer will. They're going to tell you should have been licensed and what you did was wrong. But from that perspective, you're still required, if you're using unlicensed contractors, to explain the lack of warranty and explain the lack of licensed contractors. And you'll actually see that on the seller's property disclosure statement. It asks, were licensed contractors used for the work? I cannot tell you how many times I see, well, for the work for which a license was required. If it was more than $1,000 worth of work in that house, a license was required for all of it.
So Chad, this disclosure that the seller should make, should that be on the SPUDs or should it be actually in a counter on the contract?
It should be on the SPUDs, I think. It should be on the SPUDs, but I have heard, and here's the problem, is that the way that the statute is written, it says in all sales documents, there needs to be a disclosure, but it doesn't tell you what all sales documents means. Are the sales documents the contract, or is it also the listing? Because some people, after hearing this, some brokers, and I've given this speech to a couple of different brokers, have taken the position that really it should be in the additional comments section in an MLS listing, so that people know, they can just click on that tab and see, well, here's the general that we used, here are the subs that we used. Next slide, please. This is your as-is addendum, and as we discussed, in essence, what it says is that you're waiving certain lines. And you can see the lines are referenced, line 166 through 168 of section 5A, and then essentially 169 through 170, they're not warranting anything in the property. 166 through 168 is the particulars with respect to what's being warranted, the systems, the plumbing, the electrical, pools, things like that. Next slide, please. Using a benzer. This is a little bit more applicable for agents, but as a seller or as a buyer, you should understand what a benzer is. A benzer is a buyer's inspection notice and seller's response. The idea is, I do my inspections, there are certain things that I want done. I send a list of those things over to the seller, and the seller says, yes, I will do these things, or no, I won't do these things. One of the first things that I would tell you is, if you're going through a flip and you know that it's a flip, ask for the license numbers of all the contractors who perform the work. Should be one of the conditions of the contract. If they haven't done that or they can't do that, get out or look very, very carefully at all the work that was done. Secondly, make specific repair requests. This is not a request for credits. This is something that happens all the time on these deals. You see an agent who, rather than saying, I think that you should fix the roof, I think that you should fix the plumbing, that you should fix X, Y, or Z, they use the benzer as a counter. And they write, in lieu of repairs, $20,000 credit. In lieu of repairs, $20,000 credit is a counter offer. It's not anything under the buyer's inspection notice and seller's response. You already have a deal for the property, and you have a deal for a purchase price. Technically, if your seller says, no, I really don't want to lower any portion of the purchase price, we'll just stick with the same purchase price, you're not bound to the contract. Because you haven't asked them to do anything else other than take that dollar amount. And in certain instances, title companies will take the position, and I agree with them frankly, that that's not a proper use of a benzer. It was a request for a price reduction without any consideration, in which case if somebody denies that price reduction, you're still bound to the contract. And then if you want out, you lose your earnest money deposit. And the time that it came up, we had a property in PV, and the earnest money deposit was $100,000, which is why it mattered. So when the agent came back and said, in lieu of repairs, $200,000 credit, the seller said, no, we're not going to give you the credit. The title company agreed with the seller that that was not a proper use of the benzer, and said, in essence, you either have to close or forfeit the $100,000 earnest money deposit. They ended up closing in that situation to avoid losing the deposit. So this is not what a benzer is for. Make specific repair requests. And all requests you request be made by licensed contractors. Now this is an argument with every single broker and every single agent that you will ever deal with. Happens every single time. I say, can you fix, whatever, the plumbing? Plumbing's leaking, send somebody out there. If it's a flip and they have done more than $1,000 worth of work, any of that additional work must be done by a licensed contractor. In most instances, the work must be done by a licensed contractor. By state law, again, if it's any of the big five, if it's roofing, if it's the HVAC, if it's plumbing, if it's electrical, or it's a pool, they have to send a licensed contractor out who has a specialty license. General contractors can't do any of that work unless they get separately licensed for it. There will be pushback on this, but one of the things that you should know is that a realtor can never request that you do something that's in violation of state law. And a seller can never request that you do something that's in violation of state law, like paying for a contractor to come out who's not properly licensed. Next slide, please. What happens if the contractors aren't licensed? Your buyer may provide notice of disapproval for Section 4E of the AAR residential real estate contract. And one of the things that we talk about a lot, there are people who believe that once the inspection period is over, which is normally 10 to 15 days, something like that, once that inspection period is said and done, I no longer have a right to cancel. I'm committed to the deal and I have to move forward. If there is a change during escrow and you find out about that change, you're still provided an additional 5 days after delivery of the notice to ask the seller to correct. Let's say that you find out suddenly during your walkthrough that something was done that was not disclosed and was not done by a licensee. You have 5 days then to come back and say, look, I want to close. I don't want to close any longer. I want to cancel. You're perfectly entitled to do that. So you need to provide the notice of reasonable disapproval, ask for either a licensed contractor to come out and to do the work or look over the work, or cancel the contract. Requiring licensed contractors for repairs. Now this is something that we talked about. This is when the dispute happens. You say, I want a licensed contractor to do this repair on this property. And the agent for the seller says, no, we're going to use my friend Jim. Jim is really good, you've got to trust me on this. He does this sort of thing. Don't use Jim. This is essentially the argument. It's criminally illegal to use or employ an unlicensed contractor. Again, a license is required if it's over $1,000 in the aggregate. And typically this is going to be over $1,000 if you're buying a flip. Or even if it's less than $1,000, it avoids any of the big five that we discussed and all other work. So if someone tells you we're not going to use a licensed contractor, this is your response. You have to by state law. You cannot do something illegal or make me accept something that's done illegally in order to close the deal. And that's it. Any questions?
You made a comment about within 1 year. If you do fixes on a home, you live there for over a year,
Right.
you're not obligated to have a licensed contractor listed on the sales docs.
No, you don't have to do that. You do still have to disclose that the work was done on the spuds.
Yeah.
And I was dealing with an attorney from New York on a deal where essentially he had said, well, I don't think that this is a valid issue. And it came up, I think about 2 years after the close, that they had used unlicensed people. There were some significant issues. We went to back to them, and they'd hired an attorney. They were living in New York. The attorney called and said, well, this stuff was done about 5 years ago. The way that fraud works is the statute of limitations runs from the date of discovery. So up to, there's a time frame. I've got to find out about it within 8 years, or if I find out about it within the 8th year, I get 1 more year. This had happened about 5 years prior to the closing, where the woman had done some work, didn't disclose it, and it turned out that the property had a big unlicensed, or unpermitted rather, structure. We went back to her counsel and said, needed to be disclosed that the work was done on the spuds, and he said, I don't believe you. I mean, we only have to disclose in New York, I think it's 5 years, what's been done in the last 5 years. So I showed him our spuds, and And he looked it up and he called the registrar of contractors and said, I'll be damned for writing a check, you know? I had no idea. So we're pretty gung-ho about it in Arizona. You are required to disclose anything that you know that's been done on that property the entire time that you've occupied it. Any other questions?
What to do about work that's been done, you know, doing a transaction, the owner's done work on the property,
Mm-hmm.
unlicensed work,
Right.
unpermitted, say,
Mhm.
right?